Muted.
Good afternoon, everybody. Thanks for joining us today. If you would go ahead and bring up the main screen, we're going to get started here in just a minute. We still got some people joining us, but wanted to go ahead and welcome everyone to this webinar on data security in the trenches, how to equip your employees as a first line of defense, and as importantly, keep them that way. My name is Tom Vincent. I'm an attorney here with GableGotwals. With me is Diana Vermeire, who's also with GableGotwals. Both of us lead the cybersecurity and data privacy practice group here. And speaking for myself, my experience includes a good amount of time within companies dealing with some of these issues from a corporate perspective. So as we go through this, that's one of the things we'll be focusing on, is things that you can take with you to address these issues in your workplaces.
Welcome, everyone, and I just want to second Tom's thank you and welcome to joining us today for this seminar proposal. As Tom has mentioned, I'm also an attorney here at GableGotwals, working in the area of data security and privacy. I've come to this from a perspective of working on privacy issues for many years, and as the evolution of technology and our systems internal to our organizations has changed, have been increasingly working on issues related to data security and how our agencies, our entities, our corporations best protect our interests, particularly with respect to employees and how they engage with the specific information, the confidential information that all of us work with on a regular and daily basis. So thank you again for joining us today.
And just some housekeeping very quickly. You should have received the handout via email. You can also download that from the webinar site. Also, we will be taking questions during the course of the presentation, but we'll be responding to them at the end of the presentation. You can submit them at any time, and please feel free to do so. If we can't get to your question during this presentation, our contact information will be at the end of this presentation, and feel free to contact us directly if we don't get to your question or if you have another question that comes up after the end of this. So what we're going to do is we're going to start with some discussion of the legal and regulatory context that we deal with when we talk about both privacy, data security, both on the front end in terms of the protections that are necessary, as well as what happens in the event of a failure of those protections, if there's a breach or a security incident. We don't want to spend a lot of time on this, but it's important for you all to understand the context when we talk about what can happen with respect to employee action or sometimes just as dangerously employee inaction in this area. So the laws governing this sort of information is really broad. It's at the federal and the state level, and at the federal level, it's broken out primarily among different segments, either the different types of information or the particular industry. So those of you that are in the banking or financial sector are going to be familiar, for example, with the last one on this bullet list here, Gramm-Leach-Bliley, the Financial Services Modernization Act, which deals with individual financial information. Those of you in healthcare are going to be familiar with HIPAA, which deals with protected health information. And these other particular statutes listed here deal with information in different contexts, and also different types of information. In addition, we have the particular industries that are covered. I mentioned healthcare and financial also. We also have particular issues in the legal industry, retail, and the energy sector. With respect to breaches, at the federal level, currently there is no overall federal data breach law. It's been discussed for a long time. There has been some development in a particular bill promoting a uniform federal statute. However, that has not been finalized yet. As it stands, with respect to breach laws, they typically depend upon the state of residence of the individual whose information has been breached, which is somewhat counterintuitive. You're not dealing with, for example, if you're an Oklahoma company, you don't just have to worry about the Oklahoma data security breach law, which we'll get into in some detail here in just a minute. You may have, for example, information on clients from 5 or 6 different states, and all of those state statutes have to be considered if you have a security incident or a security breach. As indicated here, California and Massachusetts have very strict laws. Massachusetts statute is broader in part because of the definition of personal information that's covered, which we'll talk about when we go into the Oklahoma statute, as well as some of the additional advanced protection that's required in Massachusetts as opposed to other states. Generally, these statutes are enforceable by the attorneys general of the states. They may require explicit attorney general notification, and more states have been communicating that even if the statute is not explicit, if there is a breach, particularly a breach of any significant size, that they expect the attorneys general to be notified. Some states also require, for example, notification of particular credit bureaus if there's a breach over a certain size, and require particular formats for that notice. California being one of them. There is a rather thorough particular form of notice that has to be provided.
So as Tom has already highlighted for us, this is an ever-changing area of the law. It's a moving target. There are numerous different pieces of legislation, whether they be federal or state, that anyone may have to consult depending on any type of breach that may occur. And so this can, what we even say today may not even be true for this area of the law in a few short weeks because of some change or adjustment that is made. So we're going to walk through the Oklahoma data breach law, not because it's definitive to all of the work or experiences that anyone participating in this webinar might experience, but as an example of what we're talking about in the context of data breach. So in Oklahoma, our statute has a very particular breach of the security system law, and it speaks to, one, the unauthorized access of information. It speaks to computerized data. It also speaks to personal information and the likelihood that some form of identity theft or fraud is likely to occur to a resident of this state. So I point out those specific language terms because it's really important to look at the issue of data breach. We hear in the news and in the press broad definitions, broad discussions about data breach, which are important and are very much what we're going to talk about and cover in this webinar. But I want to distinguish that from what the law requires and what the liability may be under the law, which is generally far more narrow than what the PR impact and the detrimental impact a breach more generally may have on a company or an entity. So when we're talking about the liability for breach under our statute, you have to meet very particular terms that are far more narrow than what may be an issue that causes a problem, either a PR or a financial problem for a company or an entity. So for instance, personal information has a very particular definition. It is going to be either the social security number or a driver's license number or financial account information, but of an individual. So you're pairing that with their name, their last name and first initial. But even when you look at that financial account information, it's not simply the fact that a bank account was out in the public or the credit card information. It actually has to be combined with security information or access code information. So you can see that's a very limited and narrow definition of what would constitute a breach under Oklahoma law, in terms of the kinds of personal information that have to make it out. But that is a narrow definition about liability as opposed to a larger issue that we'll also be discussing.
And one thing to add with respect to this definition of personal information, as we talked about before, not all states have the same definitions. Massachusetts, for example, does not require any particular security code, access code, or password to trigger coverage of first initial, last name, and account number under their definition of personal information. So in other words, it's sufficient for Massachusetts law if the first initial, last name, and account number is accessed. It does not require that additional step of a particular access code to trigger coverage by Massachusetts statute.
So I think Tom is highlighting, something that we're going to say over and over again, which is the varied approaches to the issue of the protection of data under both federal and varied state laws. And what he's pointing out, and what the point that I'm also trying to drive home, is this issue of sort of what is the narrow definition of liability, which in Oklahoma it's a narrow definition, but in Massachusetts it's a much broader one. And it's one of the things that when we do our work, we caution individuals, when something occurs and you believe that there's a possibility that sensitive information has made it to the public, we would encourage everyone to talk about that in terms of it being an incident, because it's not clear that it's a breach immediately under Oklahoma law or Massachusetts law or any of the varied laws that might come into play. And for liability purposes, which again is not really the focus of what we're talking about today, but for the purpose of liability, you want to be mindful that you may have an incident on your hand that you're going to have to work through a process to determine was it really in fact a breach. And that's again sort of the significance of walking through the Oklahoma law and its very narrow definition in terms of liability for a data breach in the state of Oklahoma. Under our law, there is a requirement of notification of the person who was impacted, but again, it's only if it's unencrypted, unredacted, personal information, right? That's not just simply that it was out there and somehow an encrypted version made it out to a person that shouldn't have had access to it. That, in fact, would not trigger a breach and notification requirement under Oklahoma law. But if you do meet the test, you have to do the notification. You also must do the notification as soon as practicable. And as I just highlighted, we're telling you, look at this incident, decide if it is an incident, determine if it's actually a breach, which means that there's a lot of quick analysis that will need to be done if, in fact, you have a breach, and you're also required to do the notice as soon as possible. And then you also have a caveat that you may have reason to delay your notification because of a law enforcement agency desire or wish. So know that you have some place to work if you find yourself in a situation where you do believe, in fact, a breach has occurred. Again, I'm making the point again, the narrow definition under Oklahoma law, the notification must occur if it is the disclosure of unencrypted information. Right, so only those, if in fact it's unencrypted information, then that's a concern that there's a possible breach. If it's encrypted information and the person who is accessing it also has access to the key, that too might trigger a breach. So again, you're going to have a lot to work through in terms of an incident and when it occurs. But you just need to be mindful of that and work through the process and be mindful not to call it a breach until you know it is a breach. And again, if you haven't met the test of the type of information being disclosed in a form that is accessible by someone who is not otherwise authorized, then you don't necessarily have the notification requirement. So all of this is the background to say, we all read the newspaper, we all see the news. Breaches are happening more frequently and more commonly than any of us would like. It is a regular occurrence. Experts in the field will talk about it is not a question of if you're going to experience an incident or a breach, but when you will actually experience a breach in and of itself. The costs are huge and significant. We see in the press today that there's lots of different disclosures that have gone on. Target's breach, Home Depot breach, more recently the Panama Papers and the release and gathering of information, and then other disclosure, which brings us to a really important point in all of this conversation, which is we're not simply talking about the narrow liability for data breach. We, in our work, really view this as an issue of protecting our clients and their interests in the very sensitive and confidential information that we all have in conducting our business on a daily basis. The release or unauthorized access or publication of sensitive information, whether or not it legally constitutes a data breach, can be incredibly damaging to our business entities and our individuals. And so when we talk about data breaches in privacy, we're not always talking about the narrow slice of liability under the law. We're talking about how do our clients best protect their business and financial interests, which may be inclusive of protecting highly personal sensitive information under the law, as well as corporate data and information, or simply information that has value to the company because it provides a competitive edge, or because they have promised their clients and customers that they are going to protect that information, whether or not there is a legal requirement that they do so.
A couple of things to that note. With respect to information or breaches that did not involve personal information or that had impact beyond the particularly personal, consider these two examples. Last year, the SEC brought an action against over 30 defendants in an insider trade. And strictly speaking, it was, I believe they refer to it as an outsider trading case. It's a situation where they had hackers that accessed a news agency and were able to obtain inside information, and with that, they generated about $100 million in illegal trading profits. And that's real money. That's not. That is not an amorphous or potential damage to someone whose bank account is accessed. I mean, that was not personal information, but there was a genuine profit and genuine impact to the market that the SEC saw with respect to that activity. And the SEC has gone so far as to require in company public filings disclosures regarding cybersecurity issues and cybersecurity risk if that is something that the company determines is an issue that it has to deal with. In addition, more from a personnel standpoint, let's consider the case of Ashley Madison. For those of you that aren't familiar with Ashley Madison, it's an online relationship enhancement site we'll call it that, whose slogan is "Life is short, have an affair." And they were hacked last year. And if you consider not only the individual damage that those persons who were identified as having accounts there suffered, consider also how much attention the actual email addresses received that were spotted. There were a number of articles in the media on addresses that ended in .gov, for example. And from a personnel standpoint, I know several HR professionals who were not looking forward to discovering that their company had employees who used their company email to sign up for Ashley Madison, as they were not looking forward to entertaining subpoenas from divorce lawyers for work emails. Again, that's not an issue of the personal information. That's an impact to the company because of that breach. And so to Diana's point, as we talk about the consequences of preventing breaches, this is the entire universe that we're talking about, not just the personal, but the corporate, and at the end, information value. So when we talk about making employees your first line of defense, the basis for what we're talking about here is really looking at this like a three-legged stool. You establish company goals, enable employees to meet them, and verify that they do. Or in short, you make sure they know what to do, you make sure they can do that, and then you make sure that they do it. And if one of those is lacking, then the security program can't stand on its own. All of these are important, and all of these serve a particular function. With respect to the company goals, the first place to begin there is by appropriate policies and procedures. Your company's overall data security policy will set the tone for the company and how your company treats data security. Is it of importance to them? Is it something that your company values? With respect to larger companies that may have multiple departments that have different sorts of issues, those policies can bring that overall company policy into focus for the employees and give them an idea of what their mission is with respect to their particular department. And then down from that, you have particular procedures which give employees the way that they need to enforce those policies, to put those into practice for their particular tasks. With respect to additional ways to establish and communicate goals, a number of companies will make public statements. I mentioned the filings, for example, 10Ks and 10Qs for public companies, but also as breaches occur, and that becomes more of an issue just for the public in general, we've seen companies that come out and talk about how they protect customers' information. And then internally, companies may issue particular marketing statements, either posters or just internal emails, reminding employees, hey, this is important. We take customers' information seriously, just like we would want our information to be taken seriously. And this is particularly important and helpful if you're dealing with any part of your workforce that may not be familiar with some of the technicalities of technology. Email or internet access, that for some people it may be the first job they've had where they've had that. It may not be in their nature to question an email that comes in or to not just click on a link on a website. And so this is a way to reinforce just that second thought for those employees. Think twice, click once. With respect to the particular policies, we generally recommend at least these sorts of policies, having an overall information security policy, not just tied to electronic information, but also referencing physical information, hard copy files, copies, things like that. But it's important to tailor that to your particular data collection and usage. Don't, for example, require the retention of information that you're not going to use, or but also don't ignore a significant component of that information in your policy and in effect force people to come up with their own protection and retention practices. An acceptable use policy is also important, as that's how many people get into the network, tied to, along with the bring your own device policy. The acceptable use policy can speak to what is an appropriate use of the company's email address to address the Ashley Madison situation. Bring your own device policies, particularly around the holidays, as people are getting all sorts of new devices that, generally speaking, they can't wait to bring to work and connect into the network. Well, it's important for the company to know that those employees understand what sorts of permissions and what sorts of risks are involved in doing that. Also, with respect to data access, we distinguish here between hard and soft access. Hard access is something most people should be familiar with. We talk there about actual systems that employees have access to. On hires, when we talk later about the onboarding process, typically when an employee is hired, there's a list of systems they get access to that they can log into to do their job, whether it's the internet, email, a particular accounting system, a financial system, trading system, for example, if it's an investment firm. Soft access, however, refers to information an employee may have access to that isn't necessarily firmly established. For example, in my former life as a bank officer, I had employees that would attend different committee meetings, and sometimes they would send me information that they had covered just to let me know what was going on. And it wasn't information necessarily that I needed access to, but I ended up with it. And this soft access is something that's important to help track and guide from a company standpoint, because particularly with remote devices, you can have very sensitive information end up in someone's iPhone or iPad or other mobile device, and it's information they're not used to having to deal with, whether, for example, it's PHI or personnel information, and they may not take the same precautions that those individuals for whom it's their job know to take. Lastly here, with respect to internal information security and classifications, it's important to know as a baseline, really, what information you have and where is it. And what information you have should dictate where it is that it's stored. If it's sensitive information, you probably shouldn't be sending it through email except to those particular individuals that need to know it. Similarly, if it's something that is less proprietary and more general, or information, for example, related to presentations like this one, where this is not proprietary or confidential information, you don't necessarily need to subject this to all of the protections of very sensitive information. Okay, going on, with respect to external policies that the public will see, it's important to have a website terms of use and privacy policy, especially as more and more websites are using different tools to track customer login, to track customer usage, to use remarketing efforts based on things like AdWords, and those things that as you browse the internet and then go to another site and all of a sudden there's an ad that pops up of a site that you looked at yesterday. It's important for companies to be clear as to how they use that information, as that is something that customers can misinterpret and often misunderstand. Also, it's something that a company has to adhere to. I've got FTC Wyndham listed here. That was a case that ultimately was decided last year, started in 2012, and Wyndham Hotels had a complaint lodged against them by the Federal Trade Commission because their privacy policy did not reflect their actual practices. And ultimately, through different court appearances, Wyndham was held to have to revise their privacy practices to meet their privacy policies, and it cost them a good amount of legal fees and bad press in having to do so. Additional safeguards, physical security requirements, particularly if you have physical information, and also clean desk policies. Very often, candidly, very difficult to enforce, but particularly with sensitive information, important to be aware of if you have cleaning crews or if you're in an area with a lot of traffic, to avoid the risk of anyone seeing such information and simply grabbing it off of your desk if it's available.
As Tom is pointing out here, each organization can use and should use its policies and procedures to set the parameters for how it's going to protect its sensitive information, its confidential information, and some of which is heavily regulated information. And in order to really ensure that your employees remain that first line of defense, you have got to inform them of those policies and procedures and those regulations and to train them effectively. So again, you have, one of the goals of your policies and procedures is to outline what's the information that you have, who should have access to it as part of their job function, limiting access to only those individuals with that job function, and to prevent sort of the mass distribution of sensitive or confidential information amongst the organization, and to be very thoughtful about what is that information and how is it being disseminated even internally within the organization. And when you can, remove sort of weak links, if you will, remove the dissemination and narrowly disseminate the most important and confidential and sensitive information so that you're less likely to experience some sort of incident or breach in the future. So when you are educating your employees, you need to be clear with them what their job function is that requires them to access certain types of information, and whether that information is, one, regulated under the laws, for those of you who are working with it, like health information or financial information. Two, how the company policies and procedures treat that information, even if that information is not otherwise regulated under laws or legislation. Three, there's oftentimes contractual commitments. In the wake of all the publicity that we've seen about the release of sensitive information, sometimes we are talking about information that is not really subject to regulation under the law, but because you have a business partner who tells you that they're going to have access through this business-to-business relationship to sensitive or confidential information, that you have an obligation to treat it a certain way. And that may not, it may be a breach of a contract term, if some information gets disseminated, but you've got to be mindful that the employees who are dealing with this information are well aware, again, of the regulations or the company policies or the contractual commitments that require them to take certain steps with that information. And then you've got to make sure that the basic preventive measures are put in place. And again, that comes into limiting access generally, and then making sure that those employees with that access and appropriate access know how to treat it and protect both themselves and the company in using that information. And in order to really audit and make sure that you're doing this, you have to test the employees. And that is walking around and spot checking sometimes. What are the hard copy documents that are easily available? Many of us have copy rooms, and if you just allow someone to print highly sensitive information and then they decided they accidentally printed an extra copy and they just throw it in a wastebasket that's available to everyone, is that good enough? Is that secure enough for any of the concerns that you might have? You will need to make sure that they understand, so again, that's hard copy. Who's accessing information? You can put software and technical protocols into your systems to prevent people from accessing information that they don't need to, but are they leaving it up on a screen for anyone to see if they walk out of their office? A lot of us who work in the context of HR are very sensitive to confidential employee information, and those good practices that we often understand and apply within our organizations in the context of HR can be applied across the board. And then obviously those of us in specific industries have even more rigid standards that we have to adhere to. Social engineering is something we call, these testing of emails, sending those emails that are just a little bit off, that says your UPS package has arrived, click on this link. Again, the most innocent of us are having a busy day and think, oh gosh, I am expecting something, and before you know it, you've opened your network or your system up because someone's clicked a link in an email that they shouldn't have. Obviously, all of us have technical safeguards against that and layers of protection built into our network, but you need to be really, mindful that if we don't keep our employees well aware of how easily they may be the victim of sort of fraudulent emails and spamming, then those are the instances where you find yourself sort of in deep water because someone's just innocently taken an act that they thought was, reasonable enough.
And one thing I wanted to add regarding the fraudulent emails that we've got up there, something that we've seen for a while in the financial services arena, but it's something that we're seeing more and more in other contexts, are actual emails from legitimate email addresses that are either customers or vendors who are requesting wire transfers of funds to accounts that do not belong to those customers or vendors. In my experience, I've seen a number of individuals with, in some cases, decades of experience who, because they did not simply call back the customer who they thought was requesting a wire, ended up transferring out tens of thousands of dollars of that customer's money. That took a long time to get even some of it back. And what had happened was that customer's email had been hacked, and the criminal used it to submit a request. So it's not just that. Keep in mind, it's not just that your company may be vulnerable, but your customers may be vulnerable as well. And it's sometimes through those vulnerabilities of your customers that your company can suffer damage as well.
Well, and on that note, I mean, the sophistication of the criminals out there who are trying to get our employees or our executives to make a bad decision along the way they're incredibly sophisticated. And so you'll hear often talk about spear phishing, right, where individuals will go out and collect personal information on an individual, and so then they can craft a very particular email that looks completely legitimate because you're referencing my husband and my children and my dog, and you seem to know so many things about me, and I guess I met you and I forgot, and next thing you know, you've innocently sort of engaged in a conversation or allowed something into your network because it seemed legitimate. And so again, this is why you test and regularly remind the best of us of what the risks are out there, and create a mechanism for individuals within your organization to raise concerns, to pick up the phone and call IT and say, I got something strange, maybe it got through our filters, can you check it out for me before I inadvertently open a door to our system that I don't want to open. And so that goes to the ability and authority, going back to our slide, if you set up a reporting and committing structure, an open policy, mechanisms that allow your employees to effectively report concerns, issues, potential problems in the context of securing your information, all the better to ensuring protection at the end of the day. It will also provide that sort of emphasis that this is an important issue for your organization, and maintaining confidential, sensitive information is a primary concern to ensure that your customers and clients are protected. And I've mentioned this already, job descriptions. One of the effective things that you're trying to do is to understand what information you have, who has access to it, who appropriately should be having access to it, and limiting access to only those individuals and not widely disseminating it. Your job descriptions and your understanding of the individual job functions are critical in doing this, and making sure that you're really only allowing that access that is based on legitimate business reasons and needs. Again, I use the HR context. There are individuals within an organization who have access to sensitive employee information, and they know and understand how to keep it confidential, and you don't let just anyone have access to that information. You can be doing that exercise and that analysis with all different kinds of information. Only those employees who work with a particular customer need access to that sensitive customer information, and perhaps you need to take steps to lock down the information so that not just anyone within the organization can access it. Again, trying to create as much protection around the information as possible. In addition, you need to do internal monitoring. Again, this goes back to sort of testing of employees. How are you going to audit this? How are you going to monitor the situation to make sure that you don't have either weak links or problems within the maintenance and protection of the information? Again, doing these exercises where you have people who are in charge of either auditing the situation, testing employees, testing the system, updating the whatever sort of software and technical safeguards that you have already put in place. That's really, really helpful. And finally, you can also use performance reviews to drive the message home. That one, that this is an important corporate organizational value, that there's a commitment to it, that you are monitoring employees' compliance with the policies and procedures that you've put in place. It can be a place where you can reward positive behaviors to reinforce and make sure that you are raising any issues or concerns with how an employee is performing on a regular basis with regard to the protection of information. And again, it's not just simply computerized data, although we oftentimes talk about data breaches in that context. This is about the release of any kind of sensitive or confidential information in whatever form that you may have it, ensuring that adequate protection for it for your corporation. So again, company goals need to be consistent and concrete. You need to be making sure that employees understand what the risks are, and it needs to be tailored to your organization. And then it needs to talk about the key company activities and who's involved, what are the issues that are at play. You know, you'll see on here a new product development. You know, sometimes people aren't like that becomes the example of important information that has value, whether or not it's triggered under a law or it is deemed personal information or confidential information. Be mindful, again, of the information that if it is disclosed publicly may result in some form of damage or lost business, lost customer confidence for your organization or entity.
And one other thing on new product development, it also goes to, as products are considered, you know, typically when considering a new product, one of the things that a company is going to look at is what's the margin on that product and what is involved in launching that product. And as a specific example, banks, for example, are not typically subject to the requirements of HIPAA regarding protected health information. However, as banks have gotten into the arena of offering lockbox services where they have clients that are healthcare providers and covered entities under HIPAA, and those banks may take in protected health information in providing those services, many banks found that they are now subject to the requirements of HIPAA and have to have a particular compliance program in place, have to follow the particular administrative, technical, and other safeguards that are required by HIPAA with respect to the information that they are receiving through providing those lockbox services. And so the profitability of that line of business, again, changes dramatically just by changing the customers that are offered that product. That's why it's very important whenever you're looking at a new product that is going to involve this any new information or particularly sensitive information, that becomes an active element of the review and development of that product, because it can have a significant impact on ultimately the profitability of the product and the resources that are necessary to implement that product.
So as we look through the issue of data security through the lens of employees, there really are three major points that it's very important to consider these issues at. It's one, when you're bringing someone on; two, when there's an internal transition or promotion or demotion within an organization; and three, finally, at termination itself. And it's critical that you are thoughtful about data security at all of these points. So in recruiting and onboarding, Tom's already touched on this. What is the company's policy about personal devices and bring your own device? That's something that should be covered when you're recruiting. Is there an expectation that individuals are going to be logged into the network through a mobile phone, for instance? And who's going to pay for that phone? Who's going to have the obligations of that phone? Again, I can't say enough that if there is no real reason for an individual employee to have access 24/7 via a mobile device to the network, probably best not to have it. We've gotten into a space that we take that as a matter of course, that that's something that we should do. It has huge employment law implications, including for the hourly employee who may be checking their email at all hours of night and day that arguably you should be compensating them for. And so you need to think twice. And I think we've gotten to a place where we don't think twice. And one of the things that we regularly urge our clients is think about that. Do you need it? And if you don't, then it's better to limit it. Same for remote accessibility. Does someone really need remote access to do their job? And if they don't give it to them. It eliminates a lot of potential problems. And also be ever mindful of what a new employee's potential obligations are to a former employer. You know, in the age of non-compete agreements and confidentiality agreements, you need to understand and make sure that you are not allowing inadvertently a new employee to violate a provision of some other obligation that they may have, or frankly, just bad business practice as well. And again, so you're setting forth for the individual that's coming on board the company's goals and values with respect to these issues, and making sure that they understand the risks that are inherent with the information that they have access to. And, you know, again, going so far as potentially even getting a certification that there's no information that is being improperly brought with them to the new employer.
And as basic as it may be, make sure your employees understand that working remotely does not mean emailing all of their company information to their home email. It's always surprising to Diana and me when we talk to clients about, well, he's very productive. He does a lot of work from home. Yeah, he takes stuff home on a flash drive and works on it there and just emails it back, which, depending on the particular information, could in and of itself be at least an incident that warrants investigation, if not an outright breach. But also, particularly when we get into the offboarding, then you've got individuals that have confidential, sensitive, valuable proprietary information on their home computers that you've got to deal with. And as we talked about before with respect to any risks communicated before access is granted, make sure your employees are aware that not everyone that sends an email is their friend. Again, that's relatively basic, but many people just don't understand that. And more often than not, they get busy, they see an email, say, oh, I must have ordered something from UPS, as an example. I'll just click on this link here. And more social engineering exercises that we've seen have shown that particularly as you go up the authority level and people become more and more busy, they may be less likely to pay attention to those specific emails.
So another important place that you have to be mindful of data security issues is when you have internal movement, promotions, a lateral move, whatever it may be. Again, you're going to need to assess what information does that employee need access to do their job function. And they may have actually had prior access to information that they will no longer need. And you should take the necessary protocols, both in terms of systems controls as well as specific communication with the employee, to limit and preclude that access on a going forward basis. Conversely, maybe they're going to have greater access than they did before. So how do you manage that, ensure that they have the access, and that they're fully informed of their obligations with respect to that access? That obviously means that HR or a supervisor or whomever is responsible for the move or the transition is working in coordination with IT to ensure that the necessary protocols and safeguards are technically applied in addition to the specific communication. And it also presents a training opportunity regarding access. Again, a reminder of the corporate goals and policies with respect to how data is protected adequately and appropriately.
And with respect to the additions and subtractions to access rights, in both of the banks I've worked for, I had at least one employee that saw access to information as something of a status symbol. And whenever there was some denial of access to information, or we had to remove that person from a particular committee simply because it wasn't part of his job, that was a discussion I had to have. That was they saw that almost as a demotion, and part of that was not establishing up front what those expectations were with respect to that access to information. You know, access to information should be based on, as Diana said, need to know, relevant to job function, not to make you feel better about yourself or to show other people how cool you are. But unfortunately, in many instances, that's how it translates. And so again, making sure that tying into the job description and the actual job functions makes it much easier to have those sorts of discussions rather than, as I've seen some managers do, reward employees with access to that information because they don't want to have that discussion.
So the obvious place you also need to be concerned about data security is at the point of termination. And obviously there are both voluntary terminations and involuntary terminations. At either of those points, you're going to remind an employee of the difference between personal information and company information, the obligations to leave or return or verify destruction of company information that an employee may have had access to. That speaks to Tom's example of someone downloading and having on their personal computer a lot of corporate information that shouldn't be there. What is your process going to be for either certification that it's been destroyed or proof that it's been destroyed and that access has been completely turned off for that individual? Obviously, in the case of an involuntary termination, you're going to need to time that with IT. We will, even if it's the best, most trustworthy employee ever, if they're being terminated for some reason, you need to be mindful of the fact that they will have access to information. If that is an involuntary termination, they may not be happy about it. So we oftentimes encourage our clients to think about whether or not the moment someone gets called in to be terminated, whether or not IT is automatically shutting down their access to at least the electronic data and their systems to prevent theft of information, which obviously does and can occur. And again, the exit interview, post-hoc interview, post-termination review of the process and what's going on. I would be remiss if I didn't note, again, when we talk about personal devices, making sure, particularly in the context of executives, that you have a copy of all relevant information on that device, particularly if you encourage your employees to use text messaging as a means of getting business done. You will want to make sure that you have access, the company has access to all information in these varied devices, but then also make sure that you remove or wipe from any device that an individual is going to be leaving with such confidential, sensitive information so that they no longer have the ability to utilize it. So there's a lot to think about in that space, in the termination space in particular, and that is really about what information is out there and have you gathered or destroyed it as necessary to fully protect the interests of the company itself.
And also along those lines, just one last thing, particularly when individuals are leaving, making sure that this is where the onboarding becomes very important. Everything that we've talked about with respect to termination, again, there's a reason we call it a reminder. This shouldn't be anything new for these employees either, because it's something that they've had at onboarding or it's been part of their regular training. They should be aware that if their device has company information on it, that it may be wiped on departure. That if they remove any company information, if they have any company information, that they need to bring it back because there could be significant consequences if they don't, legal, financial, or otherwise. And so again, getting the information to them as early as possible so that they can understand it and absorb it before you're having the already difficult conversation of surrounding an involuntary termination and then having to add on all of these other requirements that an employee may see as more punitive than as normal day-to-day company policy.
Well, we are almost out of time, and I know that we have at least one question, and that question relates to sort of data breaches themselves and how common breaches are in the state of Oklahoma, particularly if you are not a large national company like Target or Sony. So one, I'll go back to what I said earlier, which is, all of the experts in this area are going to tell you it's not an issue of if you're going to have a data breach, or we'll just say a data incident, at some point in time. The question is when. And so you hear a lot of big splashy commentary about data breaches on a regular basis, but I dare say that data incidents, data breaches, legally defined data breaches occur daily in the state of Oklahoma. And your obligations as a corporation who has any kind of customer-sensitive information in your hands, the chances of someone inadvertently walking out of your office with a document because they're going to work in hard copy from home later in the day and accidentally putting that document down and leaving it behind, that is at the very least a data incident and may in fact be a data breach under Oklahoma law. And so I use that as an example of that it happens all of the time. Tom has a perfect example of one of his clients where they had a laptop, it had relevant information for customers in several states, not simply Oklahoma. They left the laptop in their car, the car was broken into, and the laptop was stolen. They had a data breach requiring data notification and following numerous state laws because of the varied location of the individuals, the customers on that laptop. That's a data breach. That stuff happens all the time, all the time. And so we may not hear about it in the press, but what I tell my clients, you have confidential customer information, sensitive information, and if we're going to talk about specifically data breach in violation of the law, you have personally identifiable information, which every single one of you do if you have an employee, period. And that information inadvertently gets out into the wrong hands, you have a data breach. And so it happens regularly. You may not hear about it, but your need to be concerned about it, your need to put in place precautions exists for almost every entity and organization within the state, and the breaches are regular.
And along those lines, I'd say where I've seen it is in instances where individuals leave and go to a new employer. More often than not, they may take information with them, and that information may constitute a breach. Is it something that's going to necessarily be reported? No, because chances are their prior employer may not know they have it. But that would still constitute a breach. And to speak to the example that Diana mentioned about my client that had the laptop stolen, that highlights another issue beyond Oklahoma, which is when you're dealing with multiple states and multiple requirements for breach reporting, something to consider is you may have no requirement under Oklahoma to report a particular breach because, let's say, it was financial information that did not require, that didn't rise to the level of personal information under Oklahoma law, but it did under Massachusetts, in which case you would have to report it. Well, in this day and age, with the internet being the internet, someone that lives in Oklahoma could very easily find either through someone in another state who posted it on social media, or through one of a number of sites that exist solely to post examples of security breaches, that your Oklahoma company had a security breach, but you only notified customers in one particular state rather than notifying the customers in Oklahoma, which then creates its own public relations issue. So something else to consider is you may not have an incident that rises to the level of a reportable breach in one state, but if you have to report it in one state, it may be worthwhile to consider reporting it in all of them to avoid having that conversation of, why didn't you tell me there was a breach, rather than getting in front of it and notifying customers who may react much more positively in that instance than by finding out second or third hand. Are there any other questions before we sign off today? All right, it looks like we're at 1 o'clock. We certainly appreciate everyone's time. Again, our contact information is there on your screen at the end of the presentation. If you have any questions that you think of after this presentation, please don't hesitate to contact us. Also, on our website at GableLaw.com, if you go to the Cybersecurity and Data Privacy Practice page, you'll find a number of other resources, articles talking about some of the issues that we've talked about here, as well as some additional guidance on ways that you can protect your company and yourself from these sorts of incidents. With that, thank you very much, and have a great rest of the day.